Hey guys, welcome to HipHughes History. My name is Mr. Hughes, and this is a cool jacket. Yeah, baby. Thank you, Mr. McTighe. Today we're going to do Fourth Amendment, guys. We're going to take a look specifically at the language of the Fourth Amendment, and then take a look at some of the interpretations of the Fourth Amendment through selective incorporation, the Warren Court, and specifically the exclusionary rule, Mapp versus Ohio, and some of the exceptions to that rule. So I'm really excited. If you're an AP government, maybe a criminal justice class, poli-sci class, maybe you just watch Law and Order and you want to know what to yell out in the courtroom. That would be great. Maybe you're weird. Maybe you watch Jeopardy. I don't know why you're watching, but you're watching. So let's do it. Let's do it gangster style, guys. Learning is fun. Strap on your seatbelts. Get in your cars. Here we go. Beep, beep. Learning's here. Alright guys, before we do anything, take a look at the language of the Fourth Amendment because we're going to start playing with that language quite quickly. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Alright, so one thing that you want to understand is that the Fourth Amendment doesn't say anything specifically about privacy, nor does it apply to the states. The Fourth Amendment is in the Bill of Rights, and the Bill of Rights, if you've learned your lessons correctly here, applies to federal government action. It's in the U.S. federal Constitution. If you have a problem with one of your rights being violated, or whatever amendment 1 to 10, then you need to go to your state court if it's a state issue. And this is backed up in Fletcher versus Peck and 1833 court case versus Barron versus Baltimore. Both of these cases are where someone's going to the federal bench and saying my state is violating my rights, and the federal government, the judiciary, is saying too bad that you don't have a way to protect yourself with the Bill of Rights unless it's a federal action against you. So that changes really with the 14th Amendment. The 14th Amendment, which was designed to protect African Americans against kind of the Jim Crow South, didn't work for a long time, has language in it where basically it says no state shall deny its citizens equal protection but due process. And it's that due process that the federal government's going to be able to protect citizens against their state government. And you don't have to agree with this. You could disagree. You could be a Paul Bot or a libertarian and you think that this change in federalism is not right, but it is. It's what happened. So understanding that, we can then start talking about the Warren Court. You ready for the Warren Court? Get ready, because here it comes. Alright, so Earl Warren was a Republican. He was governor of California. He was a conservative governor of California as a Republican. And then Dwight Eisenhower put him on the Supreme Court. The Senate, of course, approved him. But then he kind of changes his stripes. As he gets to the court, he's like, yeah, baby, I'm different. I'm a loose interpretationalist. Now he's going to be a liberal, a progressive, using the Constitution as a living document to reinterpret the words to apply it to current day scenario. Once you're on the court, you don't have to worry anymore about getting reelected or what people think of you. You're on there forever. So Earl Warren has kind of a change of heart in terms of how he reads the Constitution. So the concept is selective incorporation. And this occurred before Warren, Gitlow versus New York, and there's some other examples. But basically, he's going to use the 14th Amendment's due process clause. No state shall deny its citizens equal protection or due process. And he's going to incorporate. Incorporate means bring into. He's going to take like a claw. You ever play the claw game in the store, right? And it's like that claw is the 14th Amendment. So you put your quarter in, you go, I want the 4th Amendment right against search warrants and, kind of protect that. And the 14th, no state shall deny its citizens due process, picks up that 4th and creates kind of a nationalized effect. And there's other court cases that you probably know of, Miranda versus Arizona. The cops in all of the states say the same thing. That's because that 5th Amendment right of self-incrimination has been selectively incorporated. So what we're talking about is, number one, taking the 4th Amendment and reinterpreting the words, and then using the 14th to selectively incorporate that. So let's do it. Mapp versus Ohio. First, let me just say this before I go over the case. Ew! All right, we're going to try to keep it straight to the facts because it's really an interesting story. There's a lot of connections. Don King, the boxing promoters, to relate it to this case. But basically, you go to Cleveland in 1957, Cleveland, Ohio, and Dorley Mapp, she was kind of a boxing lady. She was married to a boxer. She hung out with boxers. And I guess the police were investigating a bombing suspect and also somebody who was dealing with gambling and had machinery and kind of was doing that thing. And actually, through Don King's phone number, they ended up kind of tracing the trail to Miss Mapp's home. So it's not exactly Miss Mapp that they're after, but they're after the suspect, and they think that he might be at Miss Mapp's house. So 3 police officers show up at Mrs. Mapp's door. They knock, 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 and she opens the door. They go, "Can we come in?" And she says, "No way." So at that point, and she was aware, she had some legal knowledge about warrants, that they needed a warrant. So the cops kind of hang out and they kind of leave, and they come back with a whole bunch of other cops, and the next thing you know, they're banging down and busting down the door. So as they came in, Miss Mapp demanded to see a warrant. They kind of flashed a piece of paper. She stuck it down her bosom, put it in her dress. Miss Mapp's kind of a kind of that character, and they arrest her, resisting arrest, and she's being belligerent and fighting back, and yada, yada, yada. At the end of the story, they don't have a warrant, but what they do have is now free reign, of the house. And they don't find the machinery, they don't find the bomb, they don't find the suspect, but what they end up finding is kind of a suitcase near her bed or under her bed. They open up the suitcase, and ew! There's like pornography, like obscenity, like I've read child pornography, like really ew kind of stuff. So they arrest her on obscenity charges and possessing this illegal sexual material. And then that evidence is used against her in the court of law. So after her conviction, she's going to the Supreme Court, first the appeals court, up to the Supreme Court, and saying, I think the Fourth Amendment and the right to have, a protection against unreasonable searches and seizures, number one, should apply to me. Even though it's Ohio that's doing this to me, we should selectively incorporate it. But you should also make a new rule, which is if they don't have a warrant, and remember the words in the beginning of this, there's nothing in there that says what happens if they don't have a warrant. It just says you should have a warrant. So the Warren Court is going to kind of assume and make up a new precedent that if you don't have a warrant and you get this evidence, you can't use the evidence. There has to be some kind of punishment. Otherwise, why have the amendment? Why have the rule of search warrants? If you're just going to slap the cop on the wrist and the suspect's going to go to jail, a lot of cops would probably, screw the warrant, I'm getting the guy. So this creates the exclusionary rule, Mapp versus Ohio exclusionary rule, selectively incorporated, so the due process rights of Miss Mapp are being protected by the Bill of Rights, Fourth Amendment. You got it? You got it? Let's keep going, because now we're going to carve some exceptions to the exclusionary rule. So if the exclusionary rule is a piece of cheese, it would be a piece of Swiss cheese because it's got these giant holes or exceptions in it. The plain view doctrine. So this just is common sense, I think. You can disagree, but if a cop is walking by your house and you got the curtains open and the heroin in your needle, you're sticking a knife in someone's back and you're waving at the cop, they don't need a warrant. That's plain view. If you're in your car and you're driving and you got 8 pounds of meth and heroin and a big ball on the front seat, and the cop pulls up and looks over and you're petting your ball of heroin, you're going to get pulled over and arrested. That's plain view. They don't need a warrant. And that has been extended to even the smell. If you are emitting an odor of drugs and the cop doesn't need a warrant. If a dog smells it, the cop doesn't need a warrant. So the plain view doctrine is probably the biggest way to get around kind of the exclusionary rule in the Fourth Amendment. The second is U.S. versus Leon. And in U.S. versus Leon, the court ruled that there's a good faith exception. That if the cop is executing a warrant and they believe the warrant to be good, then whatever they find can stay. And there's also something called the inevitable discovery doctrine. This is the court case Nix versus Williams. These are both Rehnquist 84 cases. And basically in the inevitable discovery case, it's a disgusting case. It's a guy who murdered a 10-year-old child. Williams murdered a 10-year-old child. He disposed of the body on the side of a dirt road. And basically the cops are going to get a confession out of him illegally. His lawyer wasn't there. These are other cases. But nevertheless, they find the body illegally. But what the court says is that there was a massive search party that was searching that area. So they would have found the body anyway, inevitable discovery. So that won't be excluded. So those are the two big exceptions, and there's also other stuff in the exclusionary rule. There's the fruit of the poisonous tree. So if I find something illegally, let's say you put a map of where you buried bodies in your house. You shouldn't do this, by the way. And then I bust down your door without a warrant and I find the map. Well, the map is, going to be excluded. And all the information that I gather it, because that is, fruit of the poisonous tree. The poisonous tree being that map that I got illegally. Mapp, I'm back to Mapp. U.S. versus Mapp. Mapp versus Ohio, Hughes. What are you doing? Wow, that was a good one, guys. All right, so there you go, right? Check the links below. We got lots of awesome EDU channels down there in the description that your brain is just gonna rupture and you're gonna learn so much that you're gonna throw up like, knowledge. It'll be awesome. And certainly subscribe to HipHughes History if you haven't done that, because I got a puppy and I'm gonna hurt the puppy. If you don't subscribe, I don't wanna hurt the puppy. All right, guys, there you go. Where attention goes, energy flows. Watch other videos, learn lots, and we're out of here.